right, Abusuamicha on Amisa so a more quaba Emre channel so Abusafo ha and that's why bear media judge. Abusia, a year former finance minister kind of Ofori Atta U.S. A yadian lawyer Abba Mountain, a break silence, a war a year Ken Ofori Atta, the quarter Abusuaboko Akopium, a war a year U.S. Abusia on the 27th of a year April 2026. Nabusia, legal issues here, a just a touch. A yadian Ken Ofori Atta, the lawyer, will break silence. Na dia nsɛm na ɔde to dwa dia na betumi asi ɛwɔ ɛyɛ court charges bɛn na busua this time round ɔmo arraise on ɛyɛ Ken Ofori Atta na busua fine bɛn so na busua kyerɛ sɛ yɛde ama ɛyɛ Ken Ofori Atta na Ken Ofori Atta ne extradition process na busua akɔ akɔsisɛn na deportation no nso no abusua ɛho nsɛm akɔ akɔsisɛn ɛna ɛyɛ ade a ɛyɛ ne lawyer abusua ɛna waba waka nsɛm wa expose nsɛm abusua ene de wa fa ho expose eye onoa ne client eye Ken Ofori Atta enya asempetwa ewo eye live tv so ha ela so aye be media jecha so be so ase ene de di ko ni channel so ni de no bro kwan so abusua be so ase be subscribe like na wa bo aso ahia ma frequency ni de tie no anya bi atie ha ela so aye be media jecha
at the last count when he appeared first for the ICE hearing, you know, there was a bond application posted, and federal authorities, the lawyers from the Department of Justice, raised an issue about the extradition request. So the judge adjourned the matter to a date in February, I think February 17th or 19th, for the extradition request to be put before him so that he can consider the bond application. As it turned out, on the 19th of February, it was just a one-liner which was filed by the federal lawyers, giving no details of the request. So the judge's hands were tied. He could not go into the merits the bond application. Early on, the matter had been adjourned to the 27th of April for a continuation of the ICE hearing. So that is what we are anticipating, the 27th of April.
On the 27th of April. Are there two different cases now, in that we have the ICE detention matter, and then we also...
Yes, the ICE hearing is dealing principally with an immigration issue. You know, he applied for adjustment of his immigration status. Kenneth was supposed to exit the jurisdiction on the 14th of February. But before that, he had applied to adjust his immigration status before he was picked up by ICE. So what ICE is doing is purely an immigration matter, which is separate and distinct from the extradition request.
Okay.
That goes to a different procedure altogether. So the two cannot be commingled.
I see.
There are two different things going on at the same time.
And what you have just told us is the progress made so far on the immigration matter.
The ICE hearing, the immigration matter, but not the extradition request itself.
The assurance we keep getting is that, look, the extradition process is also going through. How is that on your side?
I don't know about that. I don't know about the extradition request or proceedings going on. I do not have any education on that. At least our counterparts in America have not told us anything about any extradition request or proceedings ongoing.
So as
those who have knowledge on that can educate Ghanaians. But sitting here,
but you must have heard the AG talk about how on November 25th or is it 29th, his visa was revoked as part of that extradition process.
His visa was revoked?
Yes.
As part of the extradition process?
Yes.
I don't know about that.
You never heard?
But
was his visa revoked?
No, but I'm saying he was to exit on February 14th.
Not exit. Revocation of your visa is different from whether or not
your
visa
I don't know. I don't know whether his visa was revoked.
How would you know that?
It is the Attorney General who is saying that, and I'm telling you, I don't know whether his visa was revoked.
No, counsel. It's either the Attorney General is wrong or he's right. So
what
was your client's visa revoked?
What I'm saying should suggest an answer to you. I said,
I don't want suggestions.
I don't know if his visa was revoked. All I know is that he applied for an adjustment of his immigration status. So if the learned Attorney General is saying that his visa was revoked, I think the burden is on
November 29th. So your client was...
The burden is on him, not me.
So the yes or no was his...
Oh, this does not suggest of a binary answer, yes or no. No, we are not doing elementary math. I'm saying that what I know is that he had applied for an adjustment of his immigration status. But you cannot
tell us whether or not his...
I don't know.
You don't know if his visa was indeed...
I don't know.
Indeed revoked.
I don't know.
You have talked a lot about the OSP's handling of the matter, but when we look at the whole picture, it's your client that has also failed to honor invitations to the OSP.
Kevin, I have decided not to talk about this OSP.
Why so?
But you see, systematically, what the OSP has done is an abuse of everything I know about criminal law. A blatant abuse. Okay? And I'll use this platform to advise my friend, my learned colleague, it's not personal, that we should at all times try to follow due process and not pander to sensationalism, press conferences, legal grandstanding, and unnecessary advertisement of ourselves. Is it not curious and a stark irony that just about 2 weeks or 3 weeks ago, I read, you also might have read that the OSP is now seeking leave of court to serve Kenneth Nanaya Kuntunkununku Ofori Atta and the other colleague, what's his name?
Ernest Akori.
Akori. With the charges preferred against them in court. That was just 2-3 weeks ago. So what do you say of the Office of the Special Prosecutor? So all this noise, this cacophony of noises that have been made about Ken Ofori Atta, he had not even been served with the criminal summons. He's not been notified of his charges. Is that a style of criminal jurisprudence? So when we filed this red notice alert against him and all that, went and embarrassed ourselves before the international community, that red notice alert was deleted because it did not conform to the rules, constitution, and regulations of Interpol. Is that what we are cutting for ourselves as a country? And you people are saying that Ken Ofori Atta is not doing what?
So
just last week, I read too that in the trial involving is it Nana? What's his name? Namwan or something? Because of his health challenges, the court has opted for a virtual hearing of the case. Is that not permissible? So when the Office of the Special Prosecutor intended to interview Kenneth Ofori Atta, when Ken had sought permission to leave the country for medical treatment, and he was outside the country, and through his lawyers, had proposed that I am ready, willing and able to assist you with your investigations. Let us do a virtual conferencing, which is permissible under law, so that you can interview me. The special prosecutor didn't want to have anything of it. He wanted to engage him like you are engaging me personally, whether he wanted to eat lunch with him, wanted to drink wine with him.
How many times did your client fail to turn up?
how many times did my client fail to turn up?
Yes,
are you counting? Are you counting the number of times
he couldn't
juxtaposing that against his medical condition? Is that what you're doing?
No, let's take it one after the other. How many times couldn't he make his meetings with the U.S.?
If I can recall, twice.
Twice?
Yeah.
I see. And your reason for that is his medical,
It's a reason which is known to you too. Didn't you know that Ken had gone for medical treatment?
Well, that's what the letter you brought from me.
Yeah, that is what the situation was.
Okay, that's what you are telling us.
Yeah, that is what the situation was.
Okay.
Yes, when the office of the special prosecutor was served with that medical letter from Mayo Clinic in the United States, where he had gone to seek treatment, he rubbished that medical thing that there was nothing to suggest that the prostate cancer that the medical facility had diagnosed as his problem was something which was bad enough not to allow him to come to this country. So he knew.
Well, because and then again, if you recall, the letter, the first letter we saw, perhaps even the only letter, there was no clear indication. It was a matter of we will observe to see if he would need surgery. That was my understanding of that letter.
Oh, but he went through surgery.
So subsequently,
he went through surgery. I say you don't know.
No, I'm just saying we are taking the matter at a time because you referred to that letter.
Yeah, but Kenneth, I'm saying, are you saying you don't know?
I'm not saying
that Kenneth went through surgery.
I'm not saying that I haven't heard that.
No, not heard. You don't know.
I don't know. I have only heard.
I'm telling you.
Okay, I have only heard that the former finance minister did undergo surgery, but in reference to that Mayo Clinic letter, they said they will look at it and see if he would need surgery.
And they looked at it, and he needed surgery, and he went
and he underwent surgery.
Yes.
There are those who argue that why does your client get to determine when he shows up to face the charges?
He has not determined when he wants to show up.
Okay.
He has not determined when he wants to show up. Okay? When he is medically challenged, he is medically challenged. Ghanaians should learn to understand when someone is sick. I mean, if I'm ill, I'm ill. And it's not as if I am jumping out of anything. I am saying I am not physically present. This is the means by which you can interview me and get what you want.
Is that also a point of argument in his case on the ICE detention as well? Because if he has undergone surgery and is ill and will not be able to fly from the U.S. to Ghana to face the charges against him, that could also be a point of contestation in the ICE detention case, is it?
There is no contestation of his health or medical challenges with ICE.
Well, but you could make the case that he is not well and shouldn't be in detention.
The lawyers there will make that case.
But
I'm part of his team.
They are your partners there.
Our partners there will make that case.
But your partners there haven't made that case.
Not yet.
What are you waiting for when you say not yet?
Oh, but why? Don't we have our style of handling matters for our client, Kevin? Yeah, we all have our style. So the criminal justice system grinds slowly, but eventually it gets to its final
Well, some think it's grinding a little too slow, particularly in certain high-profile cases.
Are we talking about particular cases? Are you talking about particular cases, or are you talking about the criminal justice system in a whole?
The criminal justice system as a whole. There are those who think that it grinds a little too slowly. It does not apply evenly. And in high-profile cases, politically exposed people are able to delay the case a lot with all kinds of legal challenges and maneuverings.
You see, when you are not confronted with a legal matter, you think that lawyers are technical, Kevin, but I don't wish one for you. But if you have a legal problem, maybe you'll be kind enough to engage me. And when you do, and I start rolling out the legal remedies available to you, you know that lawyers are not too technical after all. You see, because if I have to do a good job for you, I have to make sure that everything in the books is exhausted. So if if I'm going through that process, I do not understand why anybody should say that lawyers are being overly technical.
Are those legitimate safeguards, or they're just tools of evasion?
Oh, maybe. Okay, let's say 98 out of 100% cases are legitimate. Other lawyers.
Ugusua Ushe Jumedie no edema subscribe like to Jumedie shame nema afoforo enso ensa enya de enka be kindly click on the notification bell no so send be the any news be to platform no so a onso wahunu de aircall ene de eba POG media yedema yemko na yemfa Jumedie dodo na no enya de embra bra ofam you no ehyehyɛ so.
My client will not say that I didn't do a good job. You see, and the law allows us at every stage of the proceeding to confront issues with the superior court, which is higher than the court of first instance. So if a matter starts in the high court, there's a ruling, I'm dissatisfied with the ruling, obviously move to the court of appeal. And if I'm still dissatisfied, I move to the Supreme Court. These are remedies which are available in the law books. I mean, it is not something which is fashioned out of a vacuum. It's something that we came to meet, and that is what we will explore. So,
which means that there's a thin line between the wheel of justice grinding slowly and then the use of remedies to delay cases.
You see, I wouldn't say delay in itself of delaying. See, if I have to appeal against a ruling in a high-profile criminal matter, like you say, and the generality of Ghanaians are complaining, it means I should leave the fate of my client to the whims and caprices of maybe others who don't understand the legal system. I think that position will be challenging. That position will be challenging because due process is due process. Mm-hmm. I mean, and in every other profession, there are ways and means of challenging what is wrong and what is not too good. Mm-hmm. If you go and see a medical practitioner and you are given prescriptions to start with, and the prescription does not work,
right?
Medication does not work. Eventually, maybe if you have to go through the process of surgery, would you say your medical rights are being prolonged or delayed? So, if we should say that about lawyers, we are not being fair. I think that gradually Ghanaians should begin to understand that it is not as if we just do it out of nothing and we just want to prolong, but we have due process to follow. And when it means we should follow, we follow them.
Well, so when we flip the page on politically exposed people and the cases or corruption-related cases, and we look at the criminal justice system at large, one of the things that we had a very big challenge with is the remand system. Has that improved over the years?
There was once upon a time we started what we could call the Justice for All system.
The Justice for All program?
Where the Justice for All program, where lawyers were recruited to go to the prisons and engage people who had been in remand for an unreasonably long period of time, bring their cases to the courts, and some of them eventually secure their freedom. You see, there is something which is playing out, and if we don't confront it, it will hang around our necks with these onerous conditions of bail, which the likes of NIB, now BNI, Yoko, and others have started doing. You see, bail is a fundamental right. In the olden days, I mean, the antiquity of our legal system, bail was known as suffering an accused person to be at large. you suffer the person to be at large. You grant the person his liberties and freedom. And it's not supposed to be used as a tool of vindictive prosecution. So then a person of interest, a suspect, who is not even yet an accused person, goes to a prosecutorial institution and bail is set at 5 billion Ghana cedis with 5 sureties to be justified, landed property. Are you convicting the person before the person has his or her say in court? Because you see, a person of interest, a suspect, is not an accused person. At the end of the day, IOCO, NIB, BNI, whatever, you will have to arraign the accused person before court. And when you arraign the accused person before court, the bail conditions set by the court might be far, far, far lower than what IOCO and BNI said. So what is the justification for it? What at all is the justification? Is it to punish the people? And we look on gradually.
Why would you see that as punishment?
It is punishment.
Why so?
No, it is punishment.
Perhaps it is vis-a-vis the crime or the alleged crime.
Look, the only thing that an accused person or a person of suspect needs to do is to provide sureties. Because at the threshold, the person is not guilty. So why impose such onerous conditions of bail? Because what, you want to punish the person? The person will have to go to court. And you will have to prove the guilt. At the outset, just because the person has been arrested or the person has been invited to answer to questions and the person comes, then you want to curtail his liberties. Keep him there for an unreasonably long period of time because you have set bail at 5 million. And then you setting the bail at 5 million. Do you have property worth 5 billion? Those who set the conditions, do they have properties worth 5 billion? So that when you say I should bring sureties 5 billion, where am I going to get them?
Well, that's a lot of there's a lot of discretion in bail, right?
The discretion should be exercised judiciously, not capriciously.
The capricious part is how I'm failing to see.
You see, when an accused person or a person of interest or a suspect say, oh, he has stolen 500 million Ghana cedis, 10 billion Ghana cedis. Have you proven it?
Not yet, not at the time.
Yes, so why set bail? Because the person is supposed to have embezzled or misappropriated 500 million.
So what should we do then?
Reasonable conditions of bail.
Who is determining that reasonability?
Let the court do it.
Okay.
Let the court do it.
But our framework at this time also gives the police, IOCO, and BNI also the ability to grant bail.
They should grant police inquiry bail.
Okay.
Or investigative proceedings bail.
Right.
Bail is the preserve, the final authority on whether the accused person should be made to answer for his charges.
Which is why I'm asking.
Yes.
Outside of the court, if you get a court one, you say it's likely that the court will reason around it, and it may not be as high as those agency-related bills.
Yes.
Right. So, but at the agency level, the reasonability is on the agency to decide that this is good bail for you.
And I'm saying that discretion, Kemini, is being abused for political expediency.
Oh, really? In this country?
Yes.
How many of such have happened?
Oh, Kemini, stop this. We all be in this country. We are all here. We all be in this country. People go and, they will unreasonable, and even when somebody comes to show it is wait, come and see us tomorrow, come and see us the day.
But which is why there is also the room for you to go to court if you think the bail is not reasonable.
You see, the interval or space between when you are kept in a facility and going to the court for, you can't go to the court straight away for bail. Maybe you have to use other processes of habeas corpus. The authority will have to produce the body of the accused person. So, between the period of exhausting those procedures and when the person is in the detention facility or investigative institution facility, also has to be reckoned against criminal requirements that an accused person of interest, or a suspect should be granted bail within 48 hours. If after the 48 hours, bail is unsatisfied, you have to arraign the accused person before court. But what do we see? Most of these institutions abuse that process. Somebody will be kept for more than 2 weeks because the person has not been able to meet the bail conditions. It is not the preserve of those institutions. It is not their preserve.
How do we cure that?
It is the preserve of the court system.
How do we cure the level where the agency is able to grant bail and grant what you have called unreasonable bail?
Maybe there are practitioners who are considering bringing a writ in the Supreme Court to have the matter determined.
Not you.
When we get to that point.
When we get to that point. But overall, we've talked about the role lawyers will play in the criminal justice system. But the criminal justice system is also much more than that. Starts from the police and all these investigative agencies, the judiciary itself. How would you describe the evolution so far?
Nothing so drastic has changed. The enabling problems are when, let us speak in truth. Enabling problems are when we set up institutions as political bodies, and the idea is maybe to create the impression that some people have looted state coffers, and political parties make all kinds of promises to their supporters and to the country that people have stolen monies from the state, so we'll have to recoup or get them to account for their stewardship in state offices and governmental positions. So we create a semblance that there's a massive loot. So then when the reins of government change, the ruling government tries to maybe appease its supporters. So all manner of charges are leveled, and then people are thrown into custody and they are squeezed. I honestly, as a trained lawyer, do not see any benefit that does to our criminal justice system.
Why
the Constitution is the prevailing law of the land. And we all have to abide the dictates of the Constitution. Anything outside the remit of the Constitution is bad.
And going after people who allegedly have caused, who allegedly have been involved in corruption or corruption-related incidents is against the Constitution.
I'm not saying so. I like your choice of words. Allegedly. Maybe not that the person has committed a crime. Allegedly. So before the proven crime, let's stick with allegedly. So if it's an alleged crime, why don't you wait for the person to be convicted by a court of competent jurisdiction rather than pander to the court of public opinion?
Well, you see, I'm trying to understand exactly what you're talking about. That because if the person is politically exposed, most likely already is in the public, it becomes a high-profile case. The public will be interested, and so if the government of the day decides that we want to investigate this person for A, B, and C, why should that cause a problem?
I'm not saying it's a problem. I mean, maybe I'm honest. I'm not saying it is a problem.
Okay.
I'm saying what we do to eventually get the person to face the charges in court is where I have the problem.
What do we do? What have you seen being done?
Oh, when people are denied bail unnecessarily, they are taken through all kinds of processes which do not augur well for their personal liberties and comfort. I mean, that by itself is not something that the Constitution provides for. It frowns upon it. let us have their rights respected before they have their say in court.
Let's talk.
Aha, any the Jumadian besi at the mama subscribe like it to Jumadian shame Nema afofro and so and sa in yade and can be kindly click on the notification bell no so send a beya yeah the any news be at a platform so I want so one the echo and the bayan call na yamfa aye more stories embremo makramo.